So this is the previous year question paper which was conducted by National Testing Agency for the Junior Research Fellowship and Assistant Professor Eligibility Exam, Law June 2020, which was held on 29th of September 2020. So this is the paper 2 that deals with the law. Question number 1 is the movement of progressive society has that been a movement from status to contract. एक सोसाइटी जो कि स्टेटस से कॉन्ट्रैक्ट में सेट हुई है. The statement was made by the mean. Then next one is which of the following statement describe the relationship between the law and morality among non-positive legal theorists. तो जो नॉन पॉजिटिव लीगल थियोरिस्ट थे उनके बीच में उनके सामने लॉ और मोरालिटी के बारे में क्या ओपिनियन था. सो दे वेयर इन द ओपिनियन लाइक मोरालिटी इज जनरली इन एडवांस ऑफ द लॉ. Then question number 3 is the main purpose of the corporation's role is what? That is to maintain continuity of an office. The real relation of jurisprudence to law depends not upon what the law is treated, but the how law is treated, is said by Gray. तो the question is कि real relation of jurisprudence to law, एक jurisprudence का law के साथ क्या real relation है, वो ये नहीं है कि law क्या है जो treat कर रहा है, but important is कि law कैसे treat कर रहा है. That is very much important. So as what said by the Gray. Now in which case the Supreme Court held that the preamble does form part of the Constitution, कि preamble Constitution का part है. So that was the case of Keshwanand Bharti. Then under Article 14 of Indian Constitution, the term equal protection of the laws, so that has been taken from the American Constitution. With respect to Article 72 of Indian Constitution, it is related to the power of President to grant pardons and to suspend, remit or commute sentence in certain cases. The next one is in which case in respect of the natural justice, Lord Denning ने कहा था कि with a good man in the saddle, the unruly horse can be kept under control. यदि एक अच्छा इंसान है तो अनरूली हॉर्स को भी कंट्रोल किया जा सकता है. इट कैन जंप ओवर ऑब्स्टिकल्स, इट कैन लीप फेंसेस, पुट अप बाय फ्रिक्शंस एंड कम डाउन ऑन द अदर साइड ऑफ जस्टिस. So that was the case of India by Town Football Club Limited versus Football Association Limited. Then the word international law were used for the first time by which one of the following eminent jurists? So this was the Germany Bentham. Then Jeremy Bentham. Then question number 10 was which of the following chapter of the United Nations Charter deals with the pacific settlement of disputes? So this is chapter 6. Now in which of the following is the rule that there is a no distinction between de facto and de jure recognition for the purpose of giving effect to the internal act of the recognized authority was not applied. So that was the case of Bank of China versus Wells Fargo Bank and Union Trust. Then which of the following provision of his statute of ICJ International Court of Justice lists general principle of law recognized by civilized state as the third source of international law. So general principle of law recognized by civilized state ये third source है international law का. So that was described in Article 38 para 1C. Question number 13. An officer of a court of justice being ordered by the court to arrest Y. कोर्ट ने ऑर्डर किया वाई को अरेस्ट करने का एंड आफ्टर ड्यू इंक्वायरी गुड फेथ में है बिलीविंग जेड टू बी वाई, जेड को वाई समझ के अरेस्ट जेड एंड ई हैज़ कमिटेड, सो इट इज़ अ नो ऑफेंस. देन सेक्शन 102 ऑफ आईपीसी डील्स विद द प्रोविजन रिलेटेड टू, सो दैट इज रिलेटेड टू कमेंसमेंट एंड कंटिन्यूएंस ऑफ राइट ऑफ प्राइवेट डिफेंस ऑफ द बॉडी, कि कब से शुरू होगा और कब तक चलेगा राइट ऑफ प्राइवेट डिफेंस ऑफ द बॉडी. Then next 15, the provision regarding selling minor for the purpose of prostitution. So that is provided under section 372 of Indian Penal Code. Then next one is section 376 DB of Indian Penal Code provides for. So that is obviously 376 D stands for the gang rape. So DB there is an amendment. So it was basically for the punishment for gang rape of a woman under 12 years of age. Then question number 17 is according to whom it is a law of tort and not a law of torts. So it was Winfield. Then next one is that tort is a civil wrong for which the remedy is an action for damage and which is not exclusively breach of contract or breach of trust, a breach of mere equitable obligation. The above definition was given by Salmon. When two motorists coming from opposite direction in their car collide with each other, and in this process they injure seriously a person who was standing on the roadside, the two motorists are independent tortfeasor. They will not be considered as a joint tortfeasor. The maxim salus populi suprema lex means welfare of people is a supreme law. Question number 21 is threatening to commit certain act forbidden by IPC. To induce a person to enter into contract is associated with coercion. 22 is about an offer cannot be accepted unless it was brought to knowledge of the person to whom it is made. So that was the case of Lalman Shukla versus Gauri Dutt. Then frustration of contract occurs in two conditions. First, where the contract has become physically impossible, and secondly, where the object has failed. The above was laid down in case of Kuril versus Henry. A party who suffer loss as a result of breach of contract can in the usual course claim ordinary damage. A party who suffer loss as a result of breach of contract, just because of breach of contract a party has suffered the loss, then in that case the party will get the ordinary damage. Now, which one of the following is not an ancient source of Hindu law? So that is a precedent. It means what are the sources of Hindu law? So that is Smritis, Digest and Shruti. Then next one, which of the following is not a feature of Mitakshara Kopashnari? So it's an obstructed heritage. This is not a feature of Mitakshara Kopashnari. Then question number 27, rule relating to Sapender relationships are based on the principle of exogamy. Next one is a bigamous Hindu marriage is void and punishable. Then National Commission of Minorities was established under which of the following provision? So this was section 3 of National Commission of Minorities Act 1992. Now the chairperson of National Human Rights Commission shall be the Chief Justice of the Supreme Court. Then the Commission on the Sustainable Development was established in which year? So it was 1992. The legally binding limit to carbon emission was laid down in Kyoto Protocol on Global Warming 1997. Then the provision relating to legal recognition of electronic signature is contained under which section of IT Act 2000? So this was section 5. Then what is a whistleblower? So a person who signals illegal or unethical practice to a prescribed body. When the biological resources are accessed for the commercial utilization or the biosurvey and bio-utilization leads to commercial utilization, the applicant shall have the option to pay the benefit sharing ranging from 0.1 to 0.5. Then question number 36, by which amendment the third and fourth schedule of IT Act were omitted? So it was Act 10 of 2009. So in a parliamentary form of government, the British Convention of Ministerial Responsibility has been explicitly codified in the Indian Constitution under Article 75 Clause 3. Then which of the following is the mandatory? So option number C is right, like distribution of legislative and administrative power between the two sets of government, national and state, so as to ensure the independence of the government within their respective sphere. Then next one is 39, in which case the Supreme Court held that pardoning power of the President under Article 72 and the Governor under Article 161 is subject to judicial review. So that is Ipru Sudhakar versus State of Andhra Pradesh. Question number 40, the provision regarding legislation for the giving effect to international agreement is given in Indian Constitution under Article 253. Then 41 is which of the following duties has been included by Austin in the category of absolute duty? So the option is A, B and C. That means duty owed to person indefinitely, self-regarding duties and duty owed to the sovereign. With respect to duties owed to the parents, it has not been categorized as absolute duty. 42, which of the following conditions are essential for a custom to be valid? So for this, the correct option would be the custom had to possess a sufficient measure of antiquity. Then the B, the custom must have been enjoyed as a right. And the D option would be the custom must be certain and precise. Then which of the following are the exceptions of the specific enforcement rule of the theory of remedial liability? So that is a imperfect duty, then duty that are impossible for a specific performance, and duties which are inexpedient to enforce specifically. The provision given under Article 13 of the Indian Constitution are as follows. So A, B, and C are the correct ones. So the all laws enforced in the territory of India immediately before the commencement of this constitution will be void to the extent of inconsistency. Then the B1 is the law enforced include all the law passed or made by the legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repeated. The next one is the state shall not make any law which takes or abridges right conferred by the part third, and any law made in the contravention shall be void. Then under Article 30 of Indian Constitution, the right to minorities are guaranteed as the right is guaranteed for linguistic and religious minority. Then right is given to minority to establish and administer the educational institution, and the state is prohibited from making discrimination in the matter of grant of aid to any educational institution on the ground that it is managed by a religious minority or linguistic minority. Now the next one is not to find what is not correct, so that is not a bomb case is related to statelessness, wrong. Then the Convention on the Reduction of Statelessness 1961 was came on 13th of December 1965 was wrong. The Convention on the State of Statelessness Person was adopted on 6th of June 1960 is also wrong. But the correct is in the Hague Conference of 1930, a convention on the conflict of nationality law was signed and adopted. And on the 7th of November 1967, the General Assembly of the UN adopted the Declaration on Elimination of Discrimination against Women. Now, which of the following statements are correct? So, with respect to 47, only B and C is correct. So like the new WTO, which came into effect on 1st of January 1995, replaced the GATT. Then the function of WTO are mentioned in the Article 3 of Agreement establishing WTO. Then the provision regarding the offense against the public tranquility are as follows. So that is, whoever being aware of fact which render any assembly an unlawful assembly intentionally join that assembly or continues in it, it is said to be a member of unlawful assembly. This is the right one. Then when two or more person by fighting in a public place disturb the public peace, they are commit an affray, right? 159 is there. And then after that C is wrong, then D is right, like whoever commits an affray shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 100 rupees of with both. Then the quantum of punishment given under IPCR. So it is whoever commit extortion shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or both. For the extortion 3 saal ya fine ya both. And after that, then C option, whoever dishonestly misappropriate or convert to his own use any immovable property shall be punished with imprisonment for either description for a term which may extend to 2 years or with fine or with both. So criminal misappropriation, so that is a 2 year of fine or with both. Then question number 50 about the under section 361 of IPC, the kidnapping from lawful guardianship is, so that is when someone takes or entices any person of unsound mind out of the keeping of lawful guardianship without the consent of the guardian. So that is the correct one. And the C, when someone entices or takes away any minor under 16 years of age if male and 18 years of age if female without consent of the guardian. Option number A is wrong, like when someone takes or entices any minor without the consent of the guardian. So option A is wrong. Option B and C is correct.